Hi everyone and welcome back to your channel Lawpedia. So in this particular video we'll be understanding defamation, which has been stated in your sections 499 to 502 of the Indian Penal Code 1860. So in this particular lecture we'll be talking about reputation and how is the reputation of a person protected under the Indian Penal Code. Now before moving forward and actually understanding what the criminal defamation is all about, we must understand that what can you expect from this particular video. So the broad things that we'll be going through in this video are section 499, which deals with your definition, explanation portion and exceptions of defamation. Then we'll be looking forward towards analysis of the offense of defamation. Then we'll be understanding what is a publication and what are the various things that you must be aware about when you're knowing that what is publication in case of your criminal defamation. Next, we'll be understanding the exceptions in detail. I'll be covering one particular case law in this video, which is very important in order for you to understand what is the constitutional validity of the offense of defamation. And lastly, we'll be finishing up the video with sections 500 to section 502 of the Indian Penal Code. So without wasting any more time, let's quickly understand what is section 499 all about. So now I've divided this particular slide into two components. The first component deals with essentially what is section 499 all about, and the second component which we will be understanding in this slide are the explanations to section 499. So just reading what your section 499 states, it states that whoever by words either spoken or intended to be read or by signs or by visible representation makes or publishes any imputation concerning any person, intending to harm or knowing or having reasons that such imputation will harm the reputation of such person is said, except in the cases mentioned, to defame that person. So as you all must be aware about, next to life, what does a man or what does a person care about the most? Eventually a person cares about his or her reputation. Reputation is something that will not die with you. It will carry on even after your death. So sometimes accusation or statements or publications made against a person harming his reputation may impact him so much that it has been treated as a criminal offense. And rightly, the law gives protection to reputation as it gives protection to the life of a person. And on a careful analysis, you will observe that often the things that we do on a daily basis or things that we strive to achieve are to build up a reputation in a society. We never want to indulge in some act which destroys or harms our reputation. So what happens if some other person comes and destroys your reputation? So that's basically what section 499 does. It defines what is criminal defamation. Also, please remember, we are not protecting person's own belief of himself. What matters is the opinion of others. What do others in the society feel about you? That's what we are concerned about when we are talking about reputation, when we are talking about defamation. So it's not a matter that what you are thinking about yourself or it's an individual case. No. When we are talking about defamation, we are concerned with the society at large. And also when you read the definition, that is the section 499, you will realize publication is an essential component of defamation. And what does that mean? Let's say A says something to B directly. Direct communication to the person who is defamed will not come under the criminal defamation. However, if A says something to C about B and that is to be published further, that may amount to defamation. Why? Because that may hamper B's reputation in front of a lot of people. So that will be included under the offense of defamation. I hope you understood the broad idea of the definition. Also, when I'm talking about the term imputation, this basically means when you're accusing someone of something evil, when you're blaming someone or you're imputing someone, that is called imputation. Now let's move to the explanation part. So when you read the section 499, you will realize there are 4 explanations provided in the section itself. The first explanation basically deals with defamation of the dead. And when you read the explanation portion of this, you will realize, according to the explanation, what does the section want to imply? The section basically implies that when you're putting a blame or when you're making a defamatory statement against a deceased person or a person who is dead, it will amount to defamation if the imputation or the statement so made would harm the reputation of the person if living and is intended to be hurtful to the feelings of the family or other near relatives. Means, in the first explanation, basically the section wants to say if you're making any statement against a dead person, that can also be treated as defamation. As if the person is alive, it may harm that person's feeling, also the feelings of the surrounding family or near relatives. Now the explanation 2 basically talks about defamation of a company or a collection of persons. So basically understand this. A company or a corporation cannot be defamed in respect of a charge of murder, complaint of adultery, because of course we all know a company cannot commit that. A company can, however, hold the other person liable for defamation if the attack is on the basis of methods of conducting the affairs of the company. Let's say a person A accuses XYZ company of conducting the affairs or distribution of the corporate social responsibility funds. So that will come under your explanation 2. It may be treated as criminal defamation. So your explanation 3 basically talks about defamation by innuendo. So don't be worried. This is basically defamation in an indirect way. What do I mean by that? Let's say we are reading a particular passage and the particular passage on the first reading or on the face of it is non-defamatory. However, still the complainant can show that it is really defamatory of him from the circumstances and the nature of publication. So even though one may on the first reading not gather the defamation itself, the complainant is very much in power to show that from the nature and the surrounding circumstances of the publication, it is impacting the reputation of the person. And the explanation by which the passage is said to be defamatory is called innuendo. That means whatever explanation that has been provided that proves that the passage is defamatory is called innuendo, or saying something in an indirect. And do remember that the prosecution has to establish that the words though may appear innocent but it is not, and they were intentionally used to harm the reputation of the person. Now the last explanation that we need to read is explanation 4, that basically talks about what is harming reputation. And when you read this explanation, you will realize it basically states specific ways in which the reputation of a person may be harmed. And it states the imputation must directly or indirectly lower the morale or intellectual character of the person defamed. This is very much what we are studying up till here. So I hope you're clear with this section and the 4 explanation. Now let's move forward. So in this particular slide, we'll be covering what is defamation, and I have specified what are the essential ingredients of defamation. I hope after understanding the section from the Bare Act, you will be able to comprehend the ingredients as well. So the basic definition, basic simple term, what is defamation? It is the harm caused to the reputation of a person. Now what are the ingredients? The first and the foremost, the making and publishing of an imputation concerning any person. And the means of such imputation are words, writing, signs or visible representation. And the third aspect is it is made with the intention of harming the reputation of the person about whom the imputation is published. So basically, a slide may I have mentioned 3 essential ingredients. Let's move forward and look what is publishing all about. So जब भी हम ये term use कर रहे हैं publishing or making a statement, what do you mean by publishing? Now, whenever I'm talking about publication, first aspect इसमें ये आता है direct communication to the defamed. Suppose let's say A goes to B and directly starts using some abusive languages or states something which is not true about his or her reputation. Will it be coming under the criminal offense of defamation? No, because it's a direct communication to the person defamed. However, if A states whatever he feels about B in the newspaper or in the TV news channel which harms the reputation of B overall in the society, that will be counted as an offense of defamation. Now the second component that you must be aware about is by repetition. So what do I mean by when I am talking about by repetition? When I am talking about the term publication, it also includes repetition or republication of an already stated accusation or already stated defamatory statement. So, if a newspaper reproduces an article from another newspaper and makes the article its own, and the article was itself defamatory to some other person, such a newspaper will also be liable to the consequences resulting from its publication. What are the types of publication we have already discussed? Words spoken, written, signs and visible representation. Now last aspect we need to see is liability of the editor and others. Will the editor of a publication or a newspaper be held equally liable? That's the question over here. And the courts have stated strictly in the eyes of law, editor, printer, publisher and even distributor, please remember, is liable for printing or publishing of any defamatory matter. And why so? It is not open to the publisher to contend that he had no knowledge that the paper contained any defamatory article. So, if you are acting as an editor, printer, publisher and even distributor of the newspaper, might as well be aware about what you are publishing and ensure that it's not defamatory to some other person's reputation or conduct. Let's move forward to a very important component that we all must remember, that's your exceptions to the offense of defamation. There are 10 exceptions to defamation. So the first exception when you will read is about truth which public good requires to be published. What do I mean by that? First is truth is itself is not a defense of criminal defamation. So suppose A is making some truthful statement against B in the newspaper and then taking a defense that the statements that I've made are truthful, it will not be treated as a correct defense. However, truth for public good, that means publication of truth is a sufficient justification only if it is made in public good. No amount of truth will justify a defamatory statement unless its publication was for public good. Also, the statement that is made should be substantially true and should be made in good faith. Now, the second exception deals with public conduct of public servant. So, while the first exception dealt with expression of facts and expression of statement, the second exception deals with expression of opinion. That means if a writer publishes something in the newspaper about a public servant with all honesty and in good faith and he believes what he is publishing is true, he will not be held liable for criminal defamation. However, the writer must ensure that it is made in good faith and there is no willful misrepresentation in the same. And why so? Because fair criticism is very important for the functioning of democratic institution. Now, the third exception deals with conduct of any person, public question. This third exception means a fair comment on the public conduct of any person apart from the public servant, provided you are making the statement in good faith and it's an honest statement and it's a fair criticism. Now, the fourth exception deals with reporting of proceedings of the court. Now, When we are talking about reporting the proceedings of the court, we are talking about the citizen's right to know what's happening in the court, how is justice delivered, and how does the justice delivery mechanism operate. And when we're talking about publications of the proceeding, it need not be word to word. However, whatever you're publishing, that means जो भी आप publish कर रहे हैं, that needs to be fair, correct, and accurate. Now, the exception 5 deals with merits of the case or conduct of the witnesses. Now, exception 5 basically states that you can comment on the case adjudicated with respect to the case, conduct of parties, agents, and witnesses. Again, you must ensure that this particular statement or this particular comment is made in good faith, is fair and honest. So that's exception 5. We have done 5 exceptions. A 6th exception basically deals with literary criticism. Fair criticism to all public performances. That means now we are dealing with criticism of authors. And when I'm saying authors, what do I include in them? I include in them designers, painters, architects, editors, writers. So a person has a very much right to criticize a public performance. That way we are not directing our efforts to the reputation of the person. We are just plain simply criticizing the work, or we are just giving our opinion on the work of a person. However, there are certain conditions that the author must have invited public criticism, and the criticism must relate to the merits of performance and must be made in good faith. So very easy to understand. Exception 6 is when you express your opinion on public performances of the authors. Exception 7 basically deals with censure passed in good faith. Let's understand exception 7 with an example. A man complains the conduct of the servant to the master. So this is being done in good faith. This will not be held as a criminal defamation. Let's say, for an example, a judge censuring in good faith the conduct of a witness or of an officer of the court. Second example, a head of a department censuring in good faith those who are under his orders. And the third and the easy example is parents censuring in good faith a child in the presence of children. When we are talking about censuring, what we are referring to is to tell somebody in a strong or a formal way that he or she has done something wrong. So I hope you understood exception 7 as well. Now we moving towards exception 8. It deals with accusation preferred in good faith to authorized person. इसका example है, if A in good faith accuses Z before a magistrate, this will not be treated as criminal defamation. Second example, if A in good faith complains of the conduct of Z, a servant to Z's master, this will also not come under defamation. Now the 9th exception is protection of his or others' interest. 9th exception basically states that it is not defamation to make an imputation on the character of another, provided that the imputation be made in good faith for the protection of the interest of the person making it or of any other person or for the public good. Let's say, for an example, इसमें हम देखते हैं, let's say A एक shopkeeper है, he says to B who is managing the business of A आके B को कहते हैं कि sell nothing to Z unless he pays you the given money, for I have no opinion of his honesty. Now, इसमें what do you understand? A is within the exception if he has made this imputation on Z in good faith and for the protection of his own business. A is making this statement, so this will be an exception. Now the last statement is intended for the good of the person or public good. The statement may be for the good of the person. That means whatever statement you're making, that may be actually for the good of the person against whom you're making the statement or for a public good at large. Let's say A makes a statement to B that please do not employ my dismissed servant C, as I do not trust that person. He is a dishonest man. And this statement has been made while C is seeking employment under B. So A is under very much duty to say to B that please be aware, don't deal with persons like C. So I hope you understood all the exception. There are a bunch of exception. However, if we read it together, you'll understand there are a lot of interlinking connections between each exception. Now I want to move towards a very important case law which talks about constitutionality of section 499. Now the case law that we'll be looking forward is Subramanian Swamy versus Union of India. And what happened in the case was Supreme Court threw a bunch of writ petitions filed under Article 32 of the Indian Constitution to check the constitutional validity of section 499 and 500 along with sections 199 clause 1 to 199 clause 4 of Criminal Procedure Code. So when we're talking about section 199, I'm referring to Criminal Procedure Code, and we will be looking forward in our video towards section 499 and 500 which deal with defamation, and we are seeing what is the constitutional validity of the same. So both sides I have divided, and one side we are covering the contentions of the petitioner, on the other side I have stated the counter arguments of the respondent. When you read both the contentions of the petitioner and the counter argument, you will understand what is the constitutional validity of the criminal offense of defamation. Why are we treating the offense of defamation as a criminal offense? Why don't we just treat it as a tort and claim damages for the same? So let's understand. The first contention put forward by the petitioner was freedom of speech and expression stated under Article 19 Clause 1A. So when you read the freedom of speech and expression, it is a right that gives wide ambit and scope for a person to express his or her opinion, and it is only restricted by the reasonable restrictions provided under 19 Clause 2. So the petitioner stated that 19 Clause 2, it is not an authority, or it's not a source of authority of section 499. The section 499 that deals with criminal defamation is itself out of the scope of constitutional validity. It is not constitutionally valid to impose such a restriction on the expression of speech by the person. Next, the petitioner stated defamation is a civil wrong. Now, the other ground was it does not pass the test of reasonableness, and section 499 impacts free speech, and restriction goes beyond the requirement of public interest. And why public good? How does the section 499 satisfy public good? The counter arguments of the respondents were very basic and very clear. The right to reputation is an integral part of Article 21. So the respondents stated that if you're protecting Article 19, 1A, what about Article 21? Within which you include right to reputation as well. The respondent also stated a very valid argument that while you're reading the preamble, you find it seeks to promote fraternity, that is, respect of one another, the respect of the individual dignity of a person. So when we are talking and when we are reading, we can clearly see that there is a constitutional validity of treating it as a criminal offense of defamation, because preamble itself is stating that the constitution seeks to protect the fraternity, that is common brotherhood in the society. Now, the respondents also stated that press has great power and reckless defamatory comments are unacceptable. So when you are publishing something in press, it will not only stay today, it will not only be there tomorrow, it will be there forever. Even after the person dies, it will be there for his generations to view, or his family members to see and feel whatever they may be feeling about it. So press has a great power. Be cautious and careful with what you are publishing or stating about the other person. Next, the respondent stated the law is neither vague nor ambiguous, it's very much valid. It upholds the social stability of a society. And in the end, respondent also stated that civil remedy is not adequate. Why? Because sometimes the harm caused to the reputation may not be fulfilled by just compensation. So in the end, court held that offense of defamation does not go against the freedom of speech and expression, and hence is absolutely valid. And court also stated that when we are talking about reasonableness of the law, we'll be looking forward, or a section will be looking forward, that whether it is going beyond the objects which it is sought to achieve. That means, is the criminal offense of defamation stated under section 499 going further or going beyond the purpose that it intends to achieve, which it is not clearly, and thus section 499 is not unreasonable, arbitrary or vague. That was the decision given in this particular judgment. I hope you got a brief idea as to the constitutional validity of sections 499 and 500 after understanding the case. Now let's quickly finish the video understanding section 500 to 502, which are fairly simple. So I've just stated in one line. Basically, section 500 prescribes the punishment for defamation with a simple imprisonment for a term which makes 10 to 2 years, or with fine, or with both. It's a simple punishment section, section 500. Section 501 deals with printing or engraving matter known to be defamatory. So it basically states that whoever prints or engraves any matter knowing or having a good reason to believe that such a matter is defamatory of any person shall be punished with a simple imprisonment for a term which makes 10 to 2 years, or with fine, or with both. Now the last section is section 502, which basically deals with sale of printed or engraved substances containing defamatory matter. So when I'm saying printing of the matter, it's section 501, and when we are saying or talking about the sale of the printed matter, then we are talking about section 502. And the punishment prescribed in this particular case is also 2 years or fine, or both. I hope you got a brief idea as to what the offense of criminal defamation is all about, and what are the essential exceptions to it, what are the explanations provided in section 499, then the constitutional validity of the same with respect to the judgment, what is publication when we're talking about the offense, what is section 500, 501, 502. And thank you so much for watching. And please do like, share and subscribe if you're understanding the content. If there's any doubt specific to criminal defamation or any other video, you can definitely state them in the comment section down below. Please stay tuned for more such videos. Till then, stay home, stay safe and keep learning.